Okay, good morning, everyone. I'm going to call to order the Code Enforcement Magistrate hearing for March 19th, 2025. If you'll please rise, join me in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, please be seated. First case is not the first case on the docket. I'm going to call out of order. We've got some folks here for it. It is the Rio Garage LLC case, ZNF 2024-070638-01, and it's a violation case, and the allegation is failure to obtain a building permit when required. Ms. Bush, you're going to testify. Folks, you're here on behalf of Rio Garage?
Yes, sir.
Okay, so what we're going to do is we're going to hear from the county first. Presumably, they'll make what the law calls a prima facie case, meaning that if everything they say is correct, that there's enough there to find you responsible and guilty for the charge. After that, the burden then flips to you. You can present evidence, you can discuss the case, you can tell me your side of it, and then I'll make a ruling and we'll go about our business. So we're going to hear from the county first. I can swear you in since you're standing there, or I'll swear all three of you in if that's the case. Okay. Good. If you raise your right hands, do you swear or affirm the testimony you're about to give will be the truth, the whole truth and nothing but the truth, so help you God? All right, and I know Ms. Bush, Officer Bush, tell me your names, please.
Crystal Powell.
Crystal
Powell.
Powell, okay, Ms. Powell, and what's your relationship to Rio Garage LLC?
I'm the manager of the entity.
Okay, and sir, what's your name?
Tom Walters, property manager.
Tom Walters, and Mr. Walters, tell me again what your relationship is to the corporation?
The property manager.
Property manager, okay. But Ms. Powell, you are the actual manager of the LLC?
Legally, yes.
Got it. Okay. All right, good. So we're going to hear from the county first. You can stand there or you can sit in that first row and then look up at the monitor. That'll have the presentation and the evidence on it, as will the monitor directly in front of you. So, okay. All right. Ms. Bush, good morning.
Good morning.
Off we go. What do we got?
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Rio Garage LLC, is present. This case concerns the property at 1140 Northeast Dixie Highway in Jensen Beach, Florida, 34957 in Martin County, Florida. This case was not generated from an anonymous complaint, and according to the official records of the property appraiser of Martin County, the property owner is Rio Garage LLC. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Good.
On August 14, 2024, the property was inspected, and at that time, code enforcement investigator observed a sign with no permit, non-electric, a split unit AC. At that time, the property was photographed, and the photographs accurately shows what we saw then, and is marked as County's Exhibits 2 through 5. Exhibit 2 is the front of the building and the address.
Okay.
Exhibit 3 being the split unit AC that was installed. Exhibit 4 is a photo of the sign. Exhibit 5 is the rear of the building. Based upon the investigation, I issued a notice of violation to Rio Garage LLC on September 30th, 2024, marked as County's Exhibit 6. In the notice, I cited the following Martin County violations: Section 105.1 FBC, permits when required, incorporated by Sections 21.1 General Ordinances of Martin County Code. In the notice of violation, the respondent was given until October 30th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved. Upon inspection, observed a metal structure in the rear of the property without a permit. An amended notice of violation was issued on November 15th, 2024, and is marked as County's Exhibit 6. I'm sorry, 7.
6 is, is the original
That's
notice
our
of
notice of
violation.
violation.
That was when it
Yes,
was
sir.
Ms. Espiat's case. Now it's yours.
Yes, sir.
And you've amended for a metal structure and new sign. Okay. So, all right. And the photo,
And the structure is this structure,
okay, and
the
that's,
awning in the rear.
that's 8. I broke your train of thought. You go ahead and just tell me what you need to tell me, and then we'll go from there.
An amended notice of violation was issued on November 15, 2024, and was requesting compliance by December 5th, 2024. Upon reinspection, the photograph of the property, there was a photograph of the property of the metal awning structure on the property that had not been permitted. The photograph accurately shows what was seen then and is marked as County's Exhibit 7 through 9. Well, 8 through 9, sorry.
So 8,
Is the front of the building, which
Just the
shows
front.
that we're still at that property, and 9 being the structure that's in the rear, the awning in the rear, which Exhibit 5 shows a better photo of it than 9 does. Compliance was not achieved, and a notice of hearing was issued by certified mail on December 17, 2024, and is marked as County's Exhibit 10,
Oh.
11, I'm sorry.
yeah, 10 still a photo, 11 is the notice of hearing.
Yes.
Okay. All right, and that was for the January hearing. Okay.
Yes, sir.
Yeah, go ahead.
The owner complied with the sign violation and the removal of the split unit AC. The unpermitted structure remains on the property. A permit was submitted and additional time was granted. An amended notice of hearing was issued on February 5th, 2025, and is marked as County's Exhibit 12.
Okay.
Okay. The return receipt was not received, and the property and county administration was posted on March 5th, 2025. The posting is marked as County's Exhibit 13. And the affidavit of posting is marked as County's Exhibit 14. I'm sorry. The affidavit of posting is marked as Exhibit 13. Exhibit 14 is the property permit screenshot showing that the permit was still not issued.
Resubmittal required.
Yes, sir.
Hey, we can actually read these today. That's good. The last couple of hearings, it's been a little rough trying to read this. Okay, good.
And Exhibit 15 is the day before, which is March 18, 2025, showing that it still exists at the property. As of yesterday, the permit still has not been issued, and as it shows there, but they also reviewed it on yesterday and stated that a resubmittal would be required, and it was denied by the CRA and our building departments.
Wait a minute. The building department required a resubmittal.
Right, prior. And so this is a new resubmittal that was for yesterday.
Okay,
So basically what happened in this case is they were to get a permit for it,
right?
and then the permit was denied. They resubmitted, the permit was denied, and prior to the hearing, just so that they can try to obviously comply before the hearing, they resubmitted. So yesterday it was reviewed, and this is this is what's left for them to do,
When you,
to resubmit.
okay, so it was denied, but it is still permittable. Is that what you're
I do
telling
not
me?
know if it's permittable.
Okey dokey. All right. Well, then, let's see if Anybody else can tell us. Hang on just a sec. You all want to come up and tell me what we've got? I would tell you at the moment, I don't have a prima facie case. Let's find out what you know about it. You've heard the county's testimony and their evidence. Any objection to any of it? Looks pretty easy to me.
There's a few things I don't really agree with.
Wait a minute.
But-
It's got to be a legal objection to either the form of it or some other thing, the content. I mean, if it's a photo, it's a photo. If it's, so,
The photos are accurate. Just
Okay.
a little choice of words, but that's.
okay, but I'm not worried about that. I'm worried about the photos being correct and the documents being what they were, whether that's right or wrong, and you're going to tell me whether it's right or wrong, but, so it sounds like you really don't have any objection to any of it. It would have to be a legal objection.
Right, I mean, it looked.
Yeah.
Like it came right from the
Okay,
county.
so without objection, I will accept into evidence the county's exhibits 1 through 15. Now we can talk about them. Tell me what the story is.
So the county received a complaint from an upset prior tenant at that location, of
Okay.
course, right? And as soon as we received the notification, we immediately went to our tenant and told them they needed to cure or, would move forward with an eviction. At that time, they submitted something in December, but it wasn't the permit that they needed to submit. So then when we were notified of that, come January, they resubmitted the permit. The hearing in January was postponed, and because there was movement on obtaining the permit, and there's been movement ever since. I personally spoke with a contractor yesterday, and she said that there's a couple things that need to be work that needs to be done in order to be, pass inspections based on what the county's comments are, but it's permittable. That there's no denial, and they just need to resubmit a few things. They also said that there's issues, they're being asked to supply things and documentation for items that have to do with the building being built back in the 60s and 70s, whenever it was built. Because she's saying that they're not
County
seeing
doesn't have
permits.
them, whatever it is?
That's what she's being told.
Okay.
We also, when it comes to the tenant, we keep saying, hey, as long as the case is progressing in the right direction, the goal for everybody is compliance, and the hearings will be postponed, because that's what Tamika has said. So it was quite a shock when this one wasn't postponed, because up until, everything was in the county's review up until earlier this week. So it's like a holding pattern, where we can't the contractor cannot resubmit things that they don't know that they have to be resubmitted,
Right, until the
When it's-
county tells them what it is that's still wrong.
Right, exactly.
Yeah, no, I've got that. And I notice on the docket sheet itself, it says stipulation. And it's not being brought as a stipulation, which means that you all haven't signed an agreement.
Correct.
Are you looking for time? Is
That's
that?
what we're looking for. We're looking
is-
for time to be brought
Oh,
into
okay.
compliance.
Well, all right. I think, based on the evidence and your testimony as well as Officer Bush's, I could find a violation easily enough. But I guess I'm curious as to why you didn't enter into a stipulation.
I had a conversation with, I don't know his last name, John at the county. I believe it's.
Mr. Colando?
Hi. Yes, I had a conversation with him yesterday.
Yes?
I told him my concerns about the stipulation, that, number one, it says like all of our, right, like everything is waived. And also, as of a specific date, I'm agreeing that all these fines can be imposed no matter what. And I said, and look, as of today, everything's in the county's review.
Okay,
So-
but understand, if I find you guilty,
Right,
I'm going to do the same thing, and it's going to cost more because of the cost.
right.
The costs are 300.
Well, it's just a conversation
or-
we had. I just told him like my
Okay.
concern, like
Okay.
with the stipulation. That's all. But it's,
Well, the violation order isn't any better, not, not as far as you're concerned. I don't, do you still have that stipulation? Is that still there?
Do
I mean, is it in your file?
you have it?
Did you print it? Because all I'm saying to you is that you're better off to do it than you are to let me rule on it. And I'm happy to if you sign it. You okay with that? County okay?
Well, I point out two things. One, this case is pending for 6 months at September. The application was only made at the beginning of this year. So
Okay.
half of the time went by with no mush whatsoever. And the costs are for bringing something to hearing, which is where we are. Stipulation is done beforehand.
I get it.
Since we've incurred the cost, the county would object to not then getting the cost since we're here.
All right. I'm in the let's make a deal mode here this morning. Let's see if do you have it?
I just gave it to you.
Oh, where is it?
What are the terms of the stipulation?
On or before June 30th.
Okay, so that's enough
Get the
time.
permit.
I probably would not have given you that much time.
And, Your Honor, if I may,
You signed it?
You swear or affirm testimony about to give will be the truth, the whole truth, and nothing but the truth, so.
I do. I did
Name
try
and
to.
position.
Oh, John Colando, Code Enforcement Administrator.
Okay.
I did explain that yesterday. That's why I offered the stipulation, but we did want it back yesterday so we could do it prior to hearing.
Of course. All right, so June 30th, $100 a day?
Yes, would you?
Well, just. All right, so. All right, so it requires compliance before June 30th, on or before. Yeah, $100 a day thereafter if you fail to comply, and $350 in administrative costs to be paid basically now. And that's it. So if I rule, it's $575 in costs, then the terms would be the same or more strict. So, yes? No? I mean, I'll rule. I'm happy to rule.
I just have one other question.
Sure.
This is a beneficial owner of Rio Garage.
Yeah, I had a doctor's appointment that I didn't know
We-
it was going to be so late.
Come on up here and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
And your full name, sir?
Ryan Timothy Deering.
And Mr. Deering, what is your relationship to Rio Garage LLC?
I'm the owner of the property,
Of the land?
of the land.
Okay. All right. Okay.
Into the mic.
We don't really have a problem signing that stipulation. We hired an attorney to help us with this situation, and so we gave the tenant a 6-day notice to either get this fixed back at the original time, or else we'd evict them. Well, now my attorney's telling us that since the county agreed to let him submit a building permit application, and we agreed to let him do that, I want to go.
Can't evict them.
Right.
Yeah.
Now we're like,
So we're in this catch-22 now, because now that we all agreed to let him do this, and we agreed, and the county accepted the permit, now it's in their preview, So we can't evict him and we can't do this, and now if we sign this thing and it's still in the county, now we're in this catch-22 that we signed this, give up our rights, and we're gonna get fined, but I can't evict a guy, my hands are tied to do anything. I try to hire my own contractor, I'll take the building down, I'll do all that stuff, but right now, my hands are tied, I'm in 2 different courts now because I can't evict him because we gave him the rights to do it, and the county accepted the permit. Now, if they would just deny him, great. That would be, that's what I'd hope to happen today. If the county would just say, no, you had enough time, we're gonna cancel your permit, we'll sign this thing and then I can evict them. But right now, we're in this catch-22.
Okay, but understand, if I rule, which I'm about to do, because I got to move the docket on,
But what is that, if you rule, what does that mean?
it means that I'm going to give you less time. I'm going to probably give you until the end of May, and it's still going to be $100 a day thereafter, and I'm going to charge you $575 in costs.
No, I understand that, but I'm saying that doesn't help me out because it's
I'm-
still the building department. So we'll sign the thing that you're talking about. We have no problem with that, but is there, I'm asking your advice, I guess, where do we go from here?
I can't give you advice. All I'm telling you is that it's unusual that I see a stipulation that on the docket that turns into a violation case because they didn't sign the stipulation, which is always going to be a better deal than having it come here and me making a ruling and finding that you're responsible, which that's what the evidence shows. So,
So we sign the stipulation today, and then we just,
and you pay the $350, and then you do what you need to do between now and June 30th to either get the permit or get the tenant out and get the thing down.
all right, so we could go to the building department and say, hey, if this guy's not giving you guys what you need, then I guess we'll have to talk to the building department.
Yeah, and I can't give you legal advice on that.
Yeah, see, I'd hope John, our attorney, had this all figured out, and then all of a sudden he dropped a bomb on us and said, well, we can't do anything now.
I know what I'd be doing if I were in your shoes, but, I'd sign this.
Okay. Thank you.
All right, get your checkbook out, too, because you need to pay $350. That's got to accompany it, so. All right. Unusual, I get it, but
Actually,
all right, while you all are doing that, let me just put this on the record. So the stipulation calls for compliance on or before June 30th, 2025, failing which fine in the amount of $100 per day will accrue. And there are costs in the amount of $350 to be paid to the county today. All right. Now, failing which, this thing comes back to me, so you got to pay it, and then otherwise it's $575 and plus because there'll be another hearing. So make sure you take care of it.
sir, I think she has some additional concerns. She stated it to me, but I don't know if you want to hear those.
What concern?
What-
No, it was
Whatever.
it was more a question.
That
based
would be a
on-
question for him.
Oh, not John?
No, for the magistrate. Because it's his order, it's the magistrate's order, so.
Oh, it is. That, on the call yesterday, my main concern with the stipulation was, like, if it says June 30th and the ball is in the county's hands still, as like it was yesterday, right?
Yes.
And he said, I'm not gonna fine you or levy or put a lien on your property if it's still in review and, in the county's lap.
Okay.
Without you having defaulted.
If there is a hearing in June, and you would need to get yourself on the docket for some sort of relief, you may want to talk to your attorney about that, prior to June 30th,
Okay,
okay? So,
okay, I hear you.
So the building department, if it's their suggestion that things are moving along pretty good and they agree with us, get on the docket a couple weeks before that? Or,
if it's not resolved then you need to come back before the magic date, not after, because,
Well, what she's saying, if they're happy with the progress but it's not resolved, can they just send a letter to you, or do we still have to come to court and do the whole thing?
no, my agreed order that I'm about to give you says you've got to comply by June 30th.
Okay.
And it's up to you all to figure out how to do that.
So can we cancel it, the permit, or comply by June 30th? So if he's not getting it done and we get him just to...
Your Honor, I think these are all questions that they can call and talk to me about, and we can discuss.
Plus, you can talk to your own attorney about it. You know, it's not up to me to tell you how to comply. It's up to me to tell you you must comply. All right. Who is Seth Ellis? That's the registered agent. We don't need the registered agent.
It was either or.
Okay, so Ms. Powell, you've signed now on behalf of the owner, it's Rio Garage LLC, and I guess that's another corporation, Excursion Management LLC, what's that?
That's the legal manager of Rio Garage.
Okay, all right, and Ms. Bush, you've signed on behalf of the county. I'm going to find that it's appropriate to enter the agreed order, cut the check, so you don't get any of us in trouble, okay? We'll get you a copy of the order. Thank you. All right. Basically, you've just saved yourselves a couple $100, but you need to comply, so, okay. All right,
Your Honor, we have one more at the last one on the docket did just come in.
oh, we do, okay.
We'll receive a copy of that.
Yeah, Miss Bradley, if you just follow her, she'll get you a copy of the order. All right, okay, so you've got this other case, the Bachant case?
Yes, sir.
Gregory J. Bachant, it's case number ENF 2025-010345. Violation case for failure to obtain a building permit and a 67201B trash on the property.
Yes.
Okay, all right. I'm going to swear you in. We're going to listen to the county's evidence, okay? If you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your full name, sir?
Nick Galotta, Gulotta.
G-L-O. T-T-A?
Yes,
Glata?
correct.
All right. And what's your relationship to Mr. Bachant,
I'm the
or
property manager.
property manager? Okay. All right. Okay. Let's see what the county's got.
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Gregory J. Bachant, is not present. The case concerns the property at 2682 Northeast Pine Avenue, Jensen Beach, Florida, 34957 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Gregory J. Bachant. A copy of the property appraiser's record of ownership is County's Exhibit 1. On January 15, 2025, I inspected the property, and at that time, I observed a fence installed with no permits and overgrowth at the property. At that time, I photographed the property. The photographs accurately shows what I saw then, and it's marked as County's Exhibit 2.
Okay, what property
So-
is it?
The 2682 is this property here. Here's the fence that's in concern, the replacement of the fence, and the overgrowth.
Okay.
Based upon the investigation, I issued a notice of violation to Gregory J. Bachant on January 23, 2025, marked as County's Exhibit 3. And in the notice, I cited the following Martin County Code violations. Permits when required incorporated by Sections 21.1, Sections 105.1 FBC, General Ordinances of Martin County Code, Section 67.201A, Nuisance Declared Weeds Undergrowth, General Ordinances of Martin County Code. In the notice of violation, the respondent was given until February 23rd, 2025 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on March 5th, 2025, and is marked as County's Exhibit 6.
All right. Let me just see 6. Okay, and what's 4 and 5?
Additional photos of the property.
Okay. All right.
The return receipt was not received, and the property and county administration was posted. An affidavit of posting is marked as County's Exhibit 7 and 8. Exhibit 7 being the posting at the property, Exhibit 8 being the affidavit of the posting.
Okay.
There was no call or letter from the property owner within the time allotted. Therefore, I went to the property again on March 18, 2025, and saw that the cited violations had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 9.
And this is yesterday?
Yes. So basically, the fence is still there, but they don't have a permit. They have complied with the cut and mowing of the lawn areas. And here's a Exhibit 10 is the property screenshot for permits, showing that there is no permit for the fence.
Okay. Got it.
At this time, I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Gregory J. Bashant, be ordered to comply with the cited provisions of the Martin County Code by April 30th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting the investigation, and request that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. All right. Mr. Galata, any objection to any of those exhibits, the 1 through 10?
Well, the only objection I have, it's not a new fence.
Okay, we'll get to that.
Okay.
But the photos are accurate, okay. So without objection, I'll accept into evidence county's exhibits 1 through 10. Now, what are you telling me as far as the fence? Looks like a replacement of
Yeah,
sections of.
Storm blew section of that fence down,
Okay,
and as you can see, it was older, and so we took the opportunity to just put new material. So it's not a new fence, and it's just a repair from storm damage.
okay,
And we did take care of the overgrowth, but you can see like these palm leaves and such are from neighbors seem to think that that's a good area to dump. But we.
but that's cleared out of there. That's not an issue today.
Okay.
Okay, so, but the fence, when we've had cases like this before, where there was enough damage to the fence that the people replaced sections of it. And the county, basically, the position is that you still need a permit to replace the fence or parts of the fence. So, and the owner didn't do that. Were you the one that actually arranged for the?
No, I
the
wasn't,
work, or-
but, and I apologize for letting it get this far. There's just too many cooks in the kitchen on our side. People, thinking
Okay.
it's being handled, and it's not.
All right. I mean, there's certainly enough evidence to find the violation exists, and so I'm going to go ahead and do that based on the evidence and testimony, yours as well. Find that the violation exists, give you until April 30th should be enough time to get a fence permit.
Yes, sir.
And then if you don't do that, it'll be $100 a day. I am going to have to charge you $575 for the pleasure of coming here, so. Those are the costs incurred, so. All right. I'm going to go ahead and issue the order. And you just need to take care of it and get the fence permit done, okay? And we'll get this out to you. Do we have an email address for you?
Probably not. I'll provide my information.
Maybe just give that to Ms. Bush, and we can go from there.
Thank you, sir.
Okay. Oh, okay. Mr. Glotta, we'll get you a copy now. All right, two other matters, since we don't have anybody else out in the audience waiting. Two other matters I'm going to take care of now. Last Friday, March 14th, we received an email from Kara Groves concerning case number ENF 2022-02-01797-01, which was the Charles Chasen case from, I think it was March of 2023. And basically, on behalf of the landowner, and Ms. Groves is an attorney, she's asking that we consider a reconsideration request on the order finding violation executed by me in March 17th, 2023. And I know that also went to the staff. And Officer Counselor, you were the officer, is that correct?
Correct.
On this case? All right. And she's saying, as a brief recap, my client failed to show at the hearing, and an order was entered against him. No lien proceedings have been initiated as far as she knows, but of course the order itself is the lien. And then my client maintains that he was not on notice of this hearing until last year, when he went to submit a building permit and was required to pay magistrate fees prior to getting the permit. Through miscommunications with code enforcement, he believed that obtaining the ag classification for the upcoming year would undo the order to resolve the code enforcement case. Ag classification was denied, and Ms. Groves was hired. The client now has copies of his code enforcement of his file. He believes the mailed notices for this case were sent to the wrong address. Further, none of the notices tied with string to the gate, as shown in the code enforcement file, were actually on his gate when he visited the property. He doesn't reside there, doesn't live there. Finally, the incorrect analysis of the non-residential farm building statute under Section 604.50 Florida statutes was performed by code enforcement and misrepresented to my client. Emails between code enforcement and my client show that code enforcement took the improper position that Mr. Chasen could bypass the building permit only if he had the ag classification. This is not consistent with Florida case law or the plain language of Section 604.50. It appears members of the property appraisers, such as Dawn Jashinsky, also knew that Ms. Chasen was not required to apply for the ag classification in order to obtain protections under Florida Statute 604.50. And the respondent would like the opportunity to call said witnesses at a rehearing. Overall, it's respondent's position that he did not receive proper notice in violation of due process, and thus rehearing is proper. Further, because code enforcement maintained an improper position that Mr. Chasen was required to obtain a building permit for what was otherwise a non-residential farm building and exempt under 604.50, a reversal of the order is warranted, and respondent would appreciate the opportunity to submit an affidavit and address the 604.5 case law in a full motion. Please advise at your earliest convenience on how you'd like to proceed. So that's the email that was received, and I have not responded directly to it, I really do want to hear from the county and understand the county's position. I don't specifically remember this case, and I could probably look through it, but I found at the time that that notice was proper and that I would not have issued a violation order if I felt otherwise, as you know. And not only that, but the time for appeal of this case was 30 days from the rendering of the order. Presumably, Mr. Chasen could have appealed my decision at that point and didn't. But I think if I'm reading this correctly, what they're saying is it doesn't, none of that matters to them because apparently Mr. Chasen's case is that he didn't get actual notice. Now, notice, as we know, under the statute, is that that the code enforcement must pursue the address that's on the property appraiser's record of ownership, and that's what you do, and that's how I determine whether notice was given, and then either by certified mail, by posting, hand delivery, any of those methods are fine. So I guess I would have to review the case file to know what I did, but
If I may, Your Honor, before we even get into the specifics of the request, the county's position is that the request is improper on its face. A request for rehearing is a creature of the Florida Rules of Civil Procedure,
Right.
which is available only to a final judgment, and it must be done within 15 days of rendering that final judgment. A request for reconsideration does not appear anywhere in the Florida Rules of Civil Procedure. It's a common law practice that the Florida courts have upheld. It applies only to non-final orders. So once a final judgment is read, there is no possibility for a motion for reconsideration, and that has been addressed, even though it's not a rule. That procedure for trying to use that for a final judgment has been disallowed by the courts. And finally, the most telling thing with this is the Florida Rules of Civil Procedure do not apply here. The magistrate's hearing is controlled solely by Section 162 of the Florida statutes, which provides the only remedy for either party, respondent or petitioner, is to appeal a final judgment of the magistrate to the circuit court within 30 days. Right. Since the 30 days period has long passed, I would submit that it's improper even to consider the questions of service, even though, as the court said, that's a threshold requirement in every case, and the fact that a final order was rendered by Your Honor shows that the service was proved to be proper at the time.
yeah, and I think that's probably the key issue, is that I would not have issued a final order in this case if I was not satisfied that the county had done what it should have done to provide notice and therefore due process. I guess what I could do is treat Ms. Grove's email as a motion and deny it. Just send her an email in reply denying her motion. And basically note that it's untimely. It's way past the 30 days she had to file an appeal, and
If I might suggest, Your Honor, if you're going to treat it as a motion, could you make your response as an order denying that motion and so stating untimely?
Sure.
Since it's been done on the record.
yeah, no, I mean, unfortunately, we didn't ask her to attend. We didn't, telephonically or otherwise. But it is, I feel like because of the way she's cast this, I wish she had done this a little more formally.
The other alternative would be requested to submit a motion, which would then, we've already decided is going to be denied, so
Well,
it would be a
I
waste of judicial asset.
I mean, unless she's got something else she wants to tell us. I mean, I don't have any objection to doing that. And we could maybe hear it telephonically, you and me and,
Well, once again,
attorney.
162 controls. More than 30
does.
days have gone by. It's improper to do anything after this point. This tribunal just does not have the power to do anything other than what 162 allows.
well, I mean, there is that section, I think it's in 16209, where it does give me broad powers to issue orders
Issue would, but
that, as.
But I
fiscal
would argue that
compliance.
the 30-day cutoff for appeals trumps that. You'd issue orders up until the time that the final order, and then there's no revisiting after 30 days.
Yeah, and I'm not inclined to revisit the case, other than the fact that she may have a case for fine abatement or reduction, but that would be up to her as well. Okay, all right. I think what I'm going to do is, it requires some response, and it really is unusual to get it in this form instead of something a little more formal. But I think her request for reconsideration isn't proper. I think it's that, perhaps that's simple. That I just could treat it as a motion and deny it by way of an order. And let her then respond to that.
Yes, that,
I
we
mean,
would
I
agree.
guess she could appeal that, but,
Exactly.
yeah. Okay. All right. Okay, we've spent enough time, I think, on that. I don't know that there's much more than that, and I will deal with it. Yes, ma'am.
I just need to interrupt you for a second. On his order, you guys remove.
Oh, yeah, no, that's going to come out. Okay. And will you open the computer? Yep, thank you. All right, so that was the first issue that I had to deal with. The second one was, I had issued an order granting continuance and issuing instructions in case number ENF 2024-010023, which was County versus Lawrence H. Grubb and Dana Collins and Teresa Collins. And it came after we had taken evidence and testimony. And in my order, I note that there was this open decision that had been deferred and referred back by the Golden Gate Neighborhood Advisory Committee to Growth Management Department. And at the time, the Growth Management Department had not ruled on the request for relief. And so when I realized that, that's when I issued this order continuing the case until today. So, and Officer Counselor, you were the one that testified. So if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, so what,
Okay, so just as a follow-up,
yes,
GMD did make a final decision. They denied his alternate compliance,
okay,
basically denying his ability to have that structure permitted. So the permit was denied. He since canceled the permit because in the meantime, he went ahead and took it down.
Ah, okay,
Violation, he removed the violation.
so it's in compliance.
It's in compliance.
Okay, good. All right, so, yeah, no reason then for him to appear, and that'll take care of the case, I suppose. Procedurally, it's still an open case, so
Order dismissal?
I think that's probably the best under the circumstances. So based upon further testimony from Officer Counselor and the facts of the case being that the owner is now in compliance, I'm going to go ahead and dismiss the case. It's case number ENF 2024010023. Respondents Lawrence H. Grubb and Dana Collins and Teresa Collins. Okay, so that's dismissed.
Thank you.
All right. Okay, and let's see, I guess we're back to the top of the batting order. And it's the Heron case. Case number ENF 2024110083, Catherine Heron and the estate of Edward Heron, violation case, and, we have a new face. If you'll raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And have a seat and tell me your full name and your position.
Michael Joseph. I am a code compliance investigator for Martin County.
Okay, welcome, Mr. Joseph.
Thank you.
All right,
All right.
whenever you're ready, go ahead.
My name is Michael Joseph, and I have been sworn in. I am a code compliance investigator for Martin County. The respondent, Catherine Heron and Edward Heron estate, is not present. This case concerns the property at 6460 Southeast Lake Circle Drive, Stuart, Florida, 34997 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Catherine Heron and Edward Heron estate. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay. All right.
On November 6, 2024, Deborah Carrasco, the code officer assigned to this area, inspected the property. She observed damage to the exterior walls. She photographed the property. The photograph accurately shows what she saw then and is marked as County's Exhibit 2 through 4. So there's 2. I believe she's showing this area right here where there's damage to that exterior wall.
Okay.
Exhibit 3, see the cracking there and the damage right there. And Exhibit 4 was a door tag.
Okay.
All right. Based upon the investigation, she issued a amended notice of violation to Catherine Heron and Edward Heron estate on January 7th, 2025, marked as County's Exhibit 5. In the notice, she cited the following Martin County Code violations. Section 21.114, exterior walls, General Ordinance, Martin County Code, and 67201, weeds, which has since been removed due to an existing case. In the amended notice of violation, the respondent was given until January 28, 2025 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Deborah did another inspection on 1/29/25. Exhibit 6 accurately shows what she saw then. And there's Exhibit 6. It's still in violation.
Okay.
Compliance was not achieved, and a notice of hearing was issued by certified mail on January 31st, 2025, and is marked as County's Exhibit 7. The return receipt was not received, therefore, on March 5th, 2025, Code Enforcement Officer Deborah Carrasco posted the property and at the Martin County Administrative Building. The posting and affidavit are marked as County's Exhibit 8, 9, and 10. There's 8, the affidavit of posting. 9, the residence posted. And 10, a closer picture of the posting itself.
Okay. Got it.
Okay. No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on March 18th, 2025, and saw that the cited violation had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 11 and 12. So there, I mean, the trees have since grown over, but at the bottom there, I can try and zoom it in. You can still see that the area is still damaged and the crack's still right there.
Okay.
And 12 is the same thing, just from a different angle.
Got it.
I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Catherine Herron and Edward Herron Estate, be ordered to comply with the cited provisions of the Martin County Code by April 30th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay. All right, so just so I'm clear, the weeds and overgrowth was taken care of, or?
It was a case that was with a different code officer.
Okay, so she just,
There's an order running from a previous on that.
gotcha. Okay. So it's, yeah, it would be superfluous in this case. Okay, sure. All right. Let's see. Anybody here on behalf of Catherine Herron or the Edward Herron Estate? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 12 in this case. Based upon that evidence and your testimony, I will find that violation as charged does exist on the property. An order compliance on or before April 30th, 2025, failing which a fine in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. And just, yep, it's in there. Okay. All right. And Ms. Switzer, you have the next case. It's Sailfish Club at Jupiter Point LLC. It's case number ENF 2025-010318. And if you'll raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Good. Whenever you're ready.
My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Sailfish Club at Jupiter Point LLC, is not present and has entered into a stipulated agreement.
Okay.
This case concerns a property at 18577 Southeast Federal Highway in Tequesta, Florida 33469. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Sailfish Club at Jupiter Point LLC. Copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On January 22nd, 2025, we started a case regarding an expired permit application for a shed installation. I inspected the property and found that there are 2 sheds that were installed without an approved building permit. At the time I photographed the property, the photograph accurately shows what I saw then and is marked as County's Exhibit 2. So there's 2 sheds actually. There's one behind this bigger one that neither are permitted.
Okay. Yeah, I can kind of see the roof of the other.
Yeah.
Okay.
Based upon the investigation, I issued a notice of violation to Sailfish Club at Jupiter Point LLC on January 24th, 2025, and is marked as County's Exhibit 3. In the notice, I cited the following Martin County Code violations: Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. In the notice of violation, the respondent was given until February 14th, 2025 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on February 17th, 2025, and is marked as County's Exhibit 4. A screenshot showing the permit application status is marked as County's Exhibit 5. And that's showing that it's an expired application. The owners entered into a stipulated agreement on March 18, 2025, and has sent a signed copy. The original is being mailed to us, and they have paid the agreed fees of $350. I request that all the county's exhibits be received into evidence, and I request that the respondent, Sailfish Club at Jupiter Point LLC, be ordered to comply with the cited provisions of the Martin County Code by June 30th, 2025, and if not in compliance by then, be required to pay an amount of $100 for every day the violation continues thereafter. And this concludes my testimony.
Okay. So, without objection, I'll accept into evidence the county's exhibits 1 through 5 in this case, and based upon the stipulation which recites exactly what you just told me, I'm going to find it is appropriate to enter an agreed order in this case, and note for the record that, I'm sorry, I do or do not have the original
do not.
signature? I do not.
It's being
Okay.
mailed.
All right. So I'll enter the order, sign the order as soon as I receive the original. Okay,
Thank you.
good, thank you. All right, and the next case is the Brinson case. And Ms. Spradley, you're going to testify or no?
No, Ms. Espiat's case is actually off the docket. It was complied.
Okay. That is in compliance. Okay, and so the next one is the permit fine reduction request, okay, and it's case number 100037252. So old it doesn't even have a
I
name.
know.
Okay, let's see. All right, Denton 2 LLC,
Yes, sir.
that was the case name at the time?
Yes, sir.
Different owners now?
Correct.
Okay. All right, what have we, I have to swear you in. Do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, so what have we got?
Okay. My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 14959 Southwest 170th Avenue, Indiantown in Martin County, Florida. On June 16, 2010, an order finding violation was issued by the code enforcement magistrate to Denton 2 LLC. And a copy of the property appraisers showing the new owner. So it's Dennis Limited LLC now is the correct owner, or the current owner, rather, I'm sorry.
All right, Dennis.
And the order was issued for Section 67.201A, nuisance declared weeds, undergrowth, general ordinances, Martin County Code. Compliance was required by June 30th, 2010. On June 2018, the property was transferred over to the Village of Indiantown. On September 1st, 2021, Martin County received a payment from a surplus payment paid to a tax deed sale in the amount of $2,923.91. The property was cleared in a 2022 aerial from the property appraiser's website. So on this one, it's a little different. We did not do an affidavit of compliance due to it not being ours anymore.
Right.
But the recorded original order is County's Exhibit 2. And then Exhibit 3 is showing the payment overage that we received from the clerk for the tax deed sale. The surplus funds.
Okay.
Dennis Limited LLC are the current owners of the property pursuant to a quitclaim deed recorded in Official Record Book 3329, page 1398, Martin County, Florida, Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they brought the property into compliance and have offered to pay $0 to resolve the outstanding fines which have accrued. In addition, staff has considered the $25,000 assessed property value of the property. So we took the property value, which is the $25,000, and because we received $2,923, it was
More than
over the 10%.
Okay.
And this is a copy of Mrs. Dennis's reduction request.
Okay. Yeah, and I've got that up on my
Okay.
screen, so I read it.
So that concludes my testimony. for
Okay,
this one.
so without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case. Based upon that evidence and the request for fine reduction in your testimony, I find it is appropriate to reduce the fine to the amount that was paid basically to the county via the tax sale. All right, so as far as this reduction is concerned, it would be 0 because the county's already received the funds.
Yes, sir.
All right, note for the record that it is electronically signed by Paulette Dennis on behalf of Dennis Limited LLC, and yourself, Ms. Bradley, on behalf of the county. And I'm going to go ahead and approve the agreed recommended order. All right. Okay, good. And I'm sorry, let me just do one other thing. Okay. All right, next case is also an oldie. Case number 130074577, Douglas Taylor.
Yes, sir.
And what have we got there? Another fine reduction.
Yes.
Okay.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 6989 Southeast Ridgeway Terrace, Hope Sound in Martin County, Florida. On February 19, 2014, a stipulation and agreed final order was issued by the Code Enforcement Magistrate to Douglas Taylor for Section 67.201B, nuisance declared trash, etc., General Ordinances, Martin County Code. Compliance was required by May 19, 2014. On January 15, 2020, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $389,700. So Exhibit 1 is the property appraiser showing the new owners.
All right. THWFL Group LLC. Okay, got it.
Exhibit 2 is the original recorded stipulation with Mr. Taylor.
All right, and I'm sorry, what kind of case was it?
It was a violation case for trash and debris.
Okay. All right. Yep. I can-
And then Exhibit 3 is the recorded affidavit with accrued fines.
All right.
Okay. THW Florida Group LLC are the current owners of the property pursuant to a tax deed recorded in Official Record Book 3434, page 2519, Martin County, Florida Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they have offered to pay $0 to resolve the outstanding fines which have accrued. The county received payment from the tax deed sale in the amount of $40,676.14. And Exhibit 4 is the reduction request. And that concludes my testimony on this one.
All right. So again, the $40,676.14 is greater than 10% of the value of the
Violation.
fine. Yeah, okay. So similar to the last case, it is appropriate then to enter a fine reduction agreed recommended order, reducing the fine to 0 under the circumstances. And note for the record that Haley Dumford has signed on behalf of THWFL Group LLC, and Ms. Spradley, you've signed on behalf of the county. So I'll go ahead and issue the agreed recommended order.
Thank you.
And note that there's also an attachment from Anders Wick, who is general counsel for the LLC, advising that Haley Dumford is authorized to act on behalf of the corporation. Okay. All right. Let's see. What else have we got? The Gerson case.
Yes, sir.
Okay, and this is case ENF 2023-00860, Eric and Gabriella Gerson. And what do we got there? Also a fine reduction case.
Yes,
Okay.
sir.
Yep, go
My
ahead.
name is Rachel Spradley, and I've been sworn in. This case I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 3502 Southwest Cocoa Palm Drive, Palm City, in Martin County, Florida. On February 21st, 2024, an order finding violation was issued by the code enforcement magistrate to Eric and Gabriella Gerson for Section 105.1, permits when required incorporated by Section 21.1 General Ordinances, Martin County Code. Compliance was required by March 29th, 2024. On September 13th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $16,400 plus costs in the amount of $575. Staff has determined that a lien reduction is warranted. The respondents were responsible for the violation, and they brought the property into compliance and have offered to pay $1,697.50 to resolve the outstanding fines which have accrued by making $100 payments each month for 17 consecutive months. And said payments will be made on or before the 15th day of each month. So on this one, Exhibit 1 is the property appraiser showing Eric and Gabriella as the property owners. Exhibit 2 is the recorded order that was originally put in place for the needing a permit for the damaged roof. And then Exhibit 3 is their recorded order, or affidavit of compliance, rather, I'm sorry, showing the existing fines that are due. And that concludes my testimony for this one.
All right. All right, so without objection, I'll accept into evidence the county's exhibits 1 through 3 in this case. And based upon the stipulation, which requires $100 payments for 17 months due on the 15th of each month, Have they made any payments yet?
No, sir.
Okay, so it's just a brand-new stipulation.
Correct.
All right, and also note for the record that both Eric Gerson and Gabriella Gerson have executed on behalf of themselves, and Ms. Bradley, you've executed on behalf of the county. I'll find that it is appropriate to enter an agreed recommended order. Okay, I don't think, I can't remember another case that we had that where there was a payment plan.
In a while.
Yeah. All right. Okay, Ms. Bush, you've been sworn in. This is case number ENF 2025-010008, and the respondent is Coe's Corner LLC, and it's a 67201A weed case. What have we got?
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Coe's Corner LLC, is not present. This case concerns the property at 1814 Northeast Dixie Highway in Jensen Beach, Florida, 34957 in Martin County, Florida. This case was not generated from an anonymous complaint. And according to the official records of the property appraiser of Martin County, the property owner is Coe's Corner LLC. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On January 2nd, 2025, I inspected the property and observed overgrowth of the property. At that time, I photographed the property. The photographs accurately shows what I saw then and is marked as County's Exhibits 2 and 4. Exhibit 2 shows the overgrowth here at the property. Exhibit 4 showing the same.
All right, so three, well, let's see, it looks like there is no 2. Is there?
Exhibit 3 was taken out. It was the same photo.
Okay, duplicate?
Yes, sir.
All right, so Exhibit 2 is all the overgrowth and looks like stuff piled on the right-of-way, right?
Yes.
Okay.
I believe the stuff that was piled on the right-of-way was for pickup, being that it was in this same one section. And after going back to the property, I noticed that that did not remain, that it was picked up, but it's just the overgrowth
All right,
indeed.
and then 4, what am I looking at there?
So it's
going back.
overgrowth as well on the opposite side of the driveway.
Okay, got it. Okay, go ahead.
Based upon the investigation, I issued a notice of violation to Coe's Corner LLC on January 21st, 2025, marked as Exhibit 5. In the notice, I cited the following Martin County Code violation: Section 67.201A, nuisance declared, weeds, undergrowth, general ordinances of Martin County Code. In the notice of violation, the respondent was given until February 4th, 2025 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on February 5th, 2025, and is marked as County's Exhibit 6. Although the return receipt was received, the property in county administration was posted on March 5th, 2025. The property posting in county administration is Exhibits 7 and 8.
Your Honor, if I may just jump in here. We received a email from the respondent, Mr. Ott, at 4:30 last night, stating that the posting had the incorrect date of the hearing and a picture, and indeed, it looks like through an administrative error, it was listed the hearing date as February 19th. However, the certified mail, which is the primary means of,
Yes.
was received by him. In addition, we have copious emails from Mr. Ott requesting an adjournment of today's hearing. So he had actual knowledge of the hearing besides having the 100B knowledge.
Okay, do you all have the certified mail
I have a,
receipt and?
yes, I have, we
Okay.
printed it out, we didn't put it in, but
All
here's
right, I think,
the signed green card showing that it is indeed the one at the bottom for Coe's Corner. And that was received on February 10th.
okay,
And we request that it be entered into evidence as exhibit last.
Exhibit 9, 10. Okay. All right, so tell me again, which notice was wrong?
The notice, the posting notice, which
Okay,
it
so
wasn't
the one I'm looking
necessary,
at.
but we've developed an administrative policy of.
Doing both.
Of doing both because there's been so many illegible green cards. However, this one here is clearly signed by the respondent.
Okay, and the posting. All right. It's not possible to really read that, that posting notice. The photo isn't clear enough to actually see it. Do you have a copy of that?
Of the posting?
What was posted on the property?
No.
Maybe it's just in the photo itself, but the one I'm looking at, it's not, when I zoom in, I can't see it, can't read it.
It's too blurry.
Okay, all right, well,
We would maintain it's a moot point anyhow because a good service was obtained by the primary means.
right,
And once again, the respondent has demonstrated actual knowledge of the hearing date.
yeah, exactly, okay. All right, so Mr. Ott is not here on behalf of,
I believe there's one more exhibit that Ms. Bush has to,
Yes, sir.
I interrupted her.
oh, okay,
I therefore went to the property again on March 18th, 2025, and saw that the cited violation had not been corrected. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibit 9. And that's the photograph showing the overgrowth remains.
all right.
And this is the picture of the property on the side of it, just so that you can see the height and the difference in it. So I took the picture from this angle.
All right,
I request that all the county's exhibits be received into evidence based upon the testimony and evidence. I request that the respondent, Coos Corner LLC, be ordered to comply with the cited provisions of the Martin County Code by April 30th, 2025, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and request that the county be reimbursed this amount at the conclusion of today's hearing.
okay. All right, anybody here on behalf of Coe's Corner LLC? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 10 in this case, which includes the United States Postal Service receipt for the mailing to Mr. Ott, and find that violation as charged does exist on the property and the adjacent right-of-way to the property, and order compliance on or before April 30th, 2025, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs to the county in the amount of $575 to be paid by the respondent at the conclusion of today's hearing.
Thank you, Special Magistrate.
I just ask you just amend the record for one thing. There's actually only 9 exhibits 1 through 9 because exhibit 3 is missing.
Ah, yes, it is. Good catch. Very good. Thank you.
Thank Ms. Spradley.
That's what you get the big, that's what she gets the big bucks for. All right. 1 through 9 and no 3. All right, I'm going to change that to 9. And
1 away too.
Ms. Bradley was just trying to make sure we were paying attention.
This one's gone too.
All right, and also note for the record that I have reviewed December, January, and February minutes and found them all to be consistent with the record, and so I'm going to go ahead and execute those and get those on their way. Let's see. And I will take care of that one. And Mr. Colando, I need your signature on this set. And let's see. And now I've got the January one, and I'll enter that one. Okay, thank you. And this is December. All right, so 3 sets of minutes taken care of. And our next hearing is
April 16.
April 16th, okay. And we will see you then. We stand adjourned. Thank you.